Hello, and welcome to this month's Family Law Hour presented by Lester Law. I'm so excited to be here with you today and answer some of the most common questions that I get about divorce and custody cases in Colorado. So we'll go ahead and get started. As I mentioned, I'm an attorney. My name is Lauren Lester. I practice family law here in Colorado, and I basically help folks break up for the better. While every relationship is different, it deserves the attention that it needs, the individual attention that it needs. Please keep in mind that today I'm only going to be providing information as I go through and answer these questions, and they're going to be specific to Colorado. Every state is different and they handle divorce and custody cases different. So, if you're in another state, you'll need to find a resource applicable to your state. But if you are here in Colorado, hi, welcome, lucky you. Please keep in mind that you will want to work with an attorney about your specific situation or your specific family, and that nothing that I say today should be taken as legal advice for your particular situation. With that being said, let's go ahead and jump in and talk about the most common questions I get with divorce and custody cases. So, the first one is, do I have to actually provide all of my financial information to the other party? Whether you're going through a divorce or a custody case, there is a list of required mandatory financial disclosures, and they can be pretty lengthy depending on your situation, right? There's 3 years of tax returns, all of these bank statements, retirement statements, insurance information, right? When you go through the list, it can feel pretty overwhelming. And so it's not uncommon that I hear, like, do I really have to put all this stuff together? The answer is yes. The statute requires that you disclose all of that information without being asked by the other party, right? It's a mandatory disclosure that you have to do on your own, and you do have to provide all of that documentation. It is a good idea to redact any sensitive information so that only the last four digits of things like account numbers or social security numbers are included. So that that information is not being passed around, but you do still have to provide the full statements and all of the statements that are on that list of mandatory disclosures. This is the case even if your spouse, you think, or the other party already has a copy of something. So, especially in a divorce, you may say, my spouse has our tax return from last year. You still need to include the tax return in the information and the documents that you provide, even if it's the same document, right? If you filed jointly and that tax return is the same exact one for both of you, it still needs to be included. It may feel silly to do that because you're just exchanging the same document back and forth, but it's better to be silly than to cause any issue or any reason for the other party to say that you're not providing the financial disclosures as they are required. And that's the second question that I get all the time, right? What if the other party doesn't comply with those mandatory financial disclosures? They are mandatory, they are required. You shouldn't have to ask for them, right? But sometimes the other party just doesn't want to do it. So when that happens, there are a couple of options. First, you do want to try and resolve the issue outside of court. The other party should be aware of their requirements. It's within the statute. The court generally, when a case is filed, gives information to both parties about what's required of them. So you do want to reach out, give the other party the benefit of the doubt and say, hey, I've provided all my financial information to you. What's going on? When can I expect to get the same back? Before you start making those requests, make sure you have done your side of the agreement, right? That your side of the street is clean. You've provided all of your financial documents before you start asking the other party or accusing them of not following the same rules. But if you have done everything you're supposed to and the other party is not in compliance, if you've asked them and they just won't respond, or they say, something to the effect of, I'm just not going to do it, then generally what happens is you'll file a motion to compel with the court, which is going to let the court know that you've provided all your information. This requirement was in place. Oftentimes, the court has a deadline that's come and gone, and the other party is not in compliance. And so you can ask the court to issue an order telling the other party they need to comply. And if they continue not to provide the mandatory financial disclosures, there are sanctions that you can ask the court be put in place. If you're in that type of position, again, do talk to an attorney about your specific situation, and they can help you navigate through that and identify what sanctions are probably most appropriate. But there are consequences if a party does not comply with the requirements of the court. So, because there's so much paperwork that is involved when you get divorced or you are filing for a custody case, oftentimes folks will ask me, do they have to have all of that in place, all of those documents done before they file or start the case? And the answer there is no. There are only three documents, assuming that the parties are not filing together, that need to be filed to actually start a divorce or custody case in Colorado. Those are the petition, the case information sheet, and then again, if you're not filing together, the summons, which will be served on the other party along with the petition. So you just filed those documents that will actually start the divorce or custody case. You'll go through the first few steps. Most commonly is going to be service, and then you can start working through all the documentation, especially the financial disclosures, as the case goes on. So you don't have to have all of your ducks in a row and all of that financial information, or have talked to the other party and have a draft agreement in place to actually get the case started. And in some instances, especially with a divorce, because the 91-day waiting period is going to start once service is complete, sometimes you do want to go ahead and get the case filed, get service done, so that during that 91-day period, you can work on all those other documents, but you're not losing that additional time that the court's going to have to wait by law before it can formally end the marriage. So don't have to have everything in place, but do have to have those initial documents to file. If you go back and look at some of my prior videos, I go through those documents in detail and give you the information about where to find them and what information is going to need to be included so that you can follow that if you're looking for more information on those documents. So if you have a divorce, a question that I get often is my spouse entitled to a portion of the equity in a home that I owned before we got married? So this is a relatively common occurrence that you have two people, one of whom owns a house or a piece of property. They get married and they live in that house or property, or it's a second home for them, but only one spouse is on the title. And so I'll get questions about, is there any marital interest in that property? So in Colorado, the standard for a marital property, so something that's going to be divided as part of a divorce, is not based on titling, but is based on acquisition or whether it was held during the marriage. So in the example of I had a piece of property that I owned and then I got married to my spouse, the spouse most likely does have an interest in the equity that was accrued during the marriage. Where this tends to get tricky is usually when folks get married, they don't think to appraise the property that one of the spouses owns. And so they're trying to do that kind of retroactively because there is a divorce happening down the road. But what we're essentially looking to do is identify what the separate interest is. So the spouse who owned the property prior to the marriage, they have a separate interest that's not going to be divided as part of the divorce up until the marriage started. So we need to kind of know what the value of the property was at that time, as best as can be determined. And then during the marriage, if there was appreciation in that particular property, the spouse who doesn't own the property, who's not on the title, may have a claim to a portion of that equity. What the portion is or how it might be divided is all going to be very case specific and looking at the particulars of your situation. If this is something that you find yourself in, so that again is the place that you'll want to work with an attorney to see how it might be divided. But just know that yes, even though you're the only one on the property, the spouse was never added to the title because there was an interest that accrued during the marriage in the appreciation, then that will be a piece of marital property that has to be divided in some way during the divorce. It's going to be addressed, I should say, in some way during the divorce. So, really important to keep in mind. Is also a really good plug if you're thinking about getting married and happen to come across this live stream. It's a really great reason to have a marital agreement and go ahead and say, that property that I own before the marriage is going to entirely be mine. Even if it does appreciate during the marriage, the only way that you can write those own rules for yourself and go against the rules of the state of Colorado is to have a marital agreement. So a prenup or even a postnup in place. Absent that kind of agreement, the default in Colorado is that usually the spouse has a interest in the equity that was accrued during the marriage, even if they are not on the title. So when you have kiddos, as you can imagine, have gone through the court process, and you have a parenting plan in place that's been made in order of the court, sometimes one of the parents doesn't follow it. Usually, how this looks is one parent is not taking their parenting time. So if they, maybe have every other weekend or a couple of days every other week, there will be a parent who just won't come get the kids during that time. They won't exercise their parenting time. So I often get questions of, from the parent who now has the kids all of the time because the other parent's not exercising their time. What can they do? So there's a few different options here. I mean, yes, technically is the parent who is not exercising parenting time not following a court order? Yes. What the remedies are, even if the court gets involved and the other parent says, hey, this parent's not doing what they're supposed to be doing, the court can't make great parents. They can't force anybody to be even a good parent. What the court is there to do is make sure that kids are safe and that a basic kind of boundaries are in place around kiddos. They can't force anyone to show up as a parent if that person just doesn't want to show up as a parent. So while there is an option to file what is essentially a contempt, although is slightly different procedurally, it's called a motion concerning parenting time disputes. What the court is going to do is say, hey, you should be taking your parenting time. And if the person continues to not, there's not a lot. The judge isn't going to knock on their door, when their parenting time starts and says, hey, you got to get over and get your kids. And so what typically the parent who is having all of the parenting time will sometimes do is document that the other parent is not exercising their time and then eventually ask the court for a modification of the parenting plan to reflect what is actually happening, where the every other weekend isn't occurring and that parent is only showing up once every 2 months, and get a new order in place that reflects what the current situation is. So if the other parent isn't following a parenting plan, certainly you can get the court involved. If it's something like financials aren't being paid or they are claiming the child tax credit when it wasn't their year, something like that, certainly the court can step in and is more likely to have some sort of remedy. But when it's just the parent is not exercising their parenting time, not being communicative, kind of falling off the face of the planet, there may not be a lot other that the court can do other than say you should be doing what it says in this order. So, speaking of parenting plans, if you have parents who are getting along and co parenting, first of all, kudos to you. That's not easy to do and should be applauded and rewarded. And sometimes when that happens, life happens and kiddos grow up and schedules change and the parents work together and they find out that a different schedule or some sort of modification to their existing parenting plan is needed. And the parents talk about it and they say, yeah, you know what, we were doing a 5-2-2-5 schedule, but now the kiddos are older and we really feel like, a week on, week off schedule is just going to be better for everyone. So the parents agree and then they start going on their merry way with that new schedule. Can you do that? Modify your parenting plan on your own without going back to court? Absolutely. At the end of the day, the way that you parent and how you work together with your co parent and how y'all have rules and boundaries and schedules in place is entirely up to you if y'all are getting along. And again, that is fantastic. And the court loves to see that because that's going to be what's best for the kids, right? Is when the two parents are able to co parent and put the kids' needs first. If y'all come up with a new schedule, as attorneys, we tend to recommend that while you don't need to go back to court necessarily, it is sometimes a good idea to memorialize that new schedule or those modifications to the parenting plan and just file that agreement with the court. So it really is just a procedural kind of paperwork process. You don't have to go back to the court. It's nothing that the judge is going to, look over and review this update that you made and bring you in and have a really intimidating conversation, right? All it really does is it'll asks the court to issue a new order so that the order that is enforceable should either parent change their mind and not want to follow it anymore is actually reflective of what's going on. So like we just talked about, if the parents aren't following the plan, or even if they've come up with a new plan, we want the order of the court to reflect the current situation. So that if a parent comes along a year later and says, we agreed to this, but he's not following it or she's not following it anymore, what the court is going to compare the behavior to is an order that actually reflects what should be happening. So while you don't need the court's involvement to modify your parenting plan, if you reach an agreement with the other party, it is best to get it in writing, and it is doubly best to just file that new written signed agreement with the court, asking the court to adopt it as its new order so that it's reflective of the current situation. So going back a little bit more on, what if the other party isn't doing what they're supposed to be doing, especially when it comes to something like child support, where they have an obligation, there's an order that they have to pay a certain amount every month and it's just not being paid. Again, there's a few options here. If you can work it out with the other party outside of court, that's just going to be best for everyone. Oftentimes, though, if somebody's not paying child support, it tends to not resolve out of court. They either feel like they can't pay, they don't want to pay, they're angry about paying, whatever the situation may be. But when it comes to child support, that's usually a little bit more clear in the sense that there's an order for child support, there's a specific number on that order. There's a frequency that it needs to be paid and a deadline. And it's usually pretty clear when the other party hasn't paid it. So if you are in the position that you're supposed to be receiving child support on behalf of your child or children and you are not, you can file a contempt motion with the court. You can also use the services of the Child Support Services office, and they will kind of help you with that process as well. If the payment hasn't been made, you can also ask that an income assignment be automatically applied. So there are definitely a couple remedies there, and usually a bit easier to have the court intervene because child support is pretty clear when it needs to be paid and what the deadline is. It's also really important to keep in mind that child support in Colorado is generally paid through the age of 19. A lot of folks think that it's once the kiddo turns 18, then the child support obligation just goes away. For the most part, it's going to be at the age of 19 that the child support needs to be paid through. There are some exceptions. So, again, it's always best to check with an attorney about your particular situation, but in general, child support is paid through the age of 19. It can be modified at any time if there's going to be a 10% change in the monthly amount that's paid. So if you are in the position of you've got the child support obligation and you feel like something has happened where your income has decreased or you're just not able to pay it, you can request that it be modified. But until that request is made, that obligation is still going to be in place. It's still a court order. It's still going to accrue. There will be arrears, and there can be interest applied on top of that arrears at a pretty high rate. So you do want to make sure that child support is not only accurate, but it is being paid. It just kind of makes life a little bit easier for everybody. And at the end of the day, it is kiddos' money, and we want to make sure that certainly our children are financially provided for. So as we're working through the court process, most of the time, folks are obviously not seeing eye to eye. Certainly, if they're getting a divorce, right, there's probably a reason for that. And even, between two co-parents, although I certainly have had several parents who are just trying to memorialize the agreement that they have in place, which is fantastic. And again, should be rewarded, and the process should be as streamlined as possible for you. But if you do find yourself in the divorce or custody process or involved with the court, you may find that the court is going to require mediation. And a question I get a lot is, do I have to do that. Mediation's just not going to be successful. So do we really need to go through those hoops? Yes. If the court especially issues an order requiring mediation, yes, you do have to provide a good faith attempt to resolve the issue through mediation. Because really, at the end of the day, the reason the court includes that requirement and has most every case go to mediation is the court doesn't want to be the decision maker about your children, your finances, your life, whatever issue is before the court. They would really like you and the other party to figure it out because you are in the best position to do that, especially when we're talking about kiddos. And so the court is going to encourage and urge the parties to attend mediation to try and work it out. And you may very well be surprised. I've had several cases and clients who tell me there's absolutely no way we're going to get an agreement in mediation. And we go and we give it a good faith try. And we really try to compromise and be creative about solutions that everyone can live with. And oftentimes we do get an agreement, which is going to be the best for everybody. The parties are going to keep control of the outcome, and they're going to have a lot more input into what the resolution is versus if the court decides, then all of that control is taken out of the party's hands. So you do have to attend mediation if it's required by the court. There are a few exceptions that you can request that requirement be waived. Again, if you feel like that might be in your case, you want to talk to an attorney to make sure that you likely qualify. But it is just a good idea to try your best, attend mediation, give it a good faith try to resolve the situation, because again, you're going to keep control of the outcome when you do that. So, the last couple of questions here. Do you have to have a lawyer to go through the divorce or custody process in Colorado? You do not. The system and the process is set up for folks to complete it on their own. All of the forms are on the court's website. The court has several instructional pages that sort of goes through the process for you and what forms you need. So you do not have to have an attorney. And in fact, many and a lot of the majority of divorce and custody cases in Colorado are handled by parties who don't have, neither one of them have an attorney. But what I generally find is, as hard as the court has tried to make it as user friendly as possible, it is a complex system. There are a lot of rules, there are a lot of court rules, there's evidence rules that everyone who is in front of the court and is going through the process is required to know and follow. And that information is not really readily available. And even just, the questions that we've gone over today. A lot of folks have questions at some point, even if they're getting along with the other party. They want to know, how long do I have to pay child support? Or, he's not providing this specific document, how do I get it from him? Or she's not, cooperating to schedule a mediation. Some questions most inevitably will come up, and having someone to be able to ask those questions to that has the legal knowledge and can give you that advice can be really helpful. So while you don't have to have a lawyer to go through the divorce or custody process, and a lot of people don't, if you can find someone that will meet your needs in terms of what services you're looking for, and then also work within your budget. If it works for you, it is a really great resource to have an attorney on your side to be able to answer those questions and provide guidance as you go through the process. So you may be thinking, now the last question I get most commonly is, well, how much does it cost to hire an attorney? And that's a great question, and it'll depend on whom you hire and how they work. So if you hire a traditional attorney who typically charges a retainer of several $1,000s up front and then is going to bill against that retainer by an hourly rate for how much time they spend or their staff spends on your case. Typically, the last numbers that I have heard is that a divorce or custody case can be at the cost of about $10,000 to $20,000 per party. Certainly, if there's a lot of contention, there's a lot of conflict, litigation, discovery request, all of that can certainly ratchet up that cost even higher. But even kind of in your, run of the mill, everyday folks who, are trying really hard, but just, need some help finding that common ground, or there's just some things that, they really need some extra work going through, you're looking at that $10,000 to $20,000 range on average. So If that doesn't work for your budget, which is understandable because it doesn't work for most of our budgets, there are alternative options out there for attorneys who offer either a flat fee, so they're going to give you the cost up front and you can make sure it does work for your budget. Oftentimes, with more traditional approach, they will give you a number for a retainer, but it is often hard to get a number in the total and kind of what it's going to be in the end from those attorneys who practice more traditionally. So if you really want to know what it's going to cost and have some of that certainty, finding someone who's going to be able to give that to you, usually through a flat fee price, is going to be best. And then there's also attorneys who don't offer a one size fits all service offering, right? Just like when you go to the sandwich shop and build your own sandwich and choose, that you want turkey and onions and cheese, but you don't want pickles, you should be able to do something similar with your attorney because there may be parts of the divorce or custody process you're comfortable doing on your own. And you just want the attorney there to provide guidance, or maybe all of the paperwork is really overwhelming. And so you would actually like the attorney to be more involved. You should be able to pick and choose the level of service. And when you find an attorney who offers different levels of service where you can customize the solution you get, that can also be really helpful so that you are paying only for the help that you need. And so those attorneys are all throughout Colorado. It is in your control and your choice on whom you work with. And if you call someone up and how they work is just not a good fit for you, there's many of us. And so you can certainly call the next attorney. If you'd like an example or certainly someone to start with, I'd be happy for you to visit my website, which is mylifelawyer.com. Again, mylifelawyer.com. You'll see all of my services as well as the pricing for divorce and custody help. And that will give you certainly an option there, but also an idea of what to look for if you are shopping around for attorneys. Finding someone who is going to provide similar information is going to help you make the best decision for yourself and your family. Lastly, if you're just looking to go through the divorce process and you'd really like to do it on your own, but just want some more instructions that make a little bit more sense than maybe the ones the court provide or a little bit more fleshed out and comprehensive, I do also offer a DIY guide for both divorce and custody. And you can sign up for that at any time at colawguides.com. Again, the information will also be below in the description, but you can sign up at CO for Colorado lawguides.com, and that'll take you from start to finish through the divorce or custody process, so that you can get that information you need to make sure that you're not missing anything, and save you and your children, make sure that your interests are being protected and that you're not missing anything in terms of your rights. So, two resources, hopefully, that will be helpful today. I hope all of these common questions and getting some answers to them was also helpful. Again, do reach out to an attorney if you have any questions about your specific situation, want to know if there's maybe an exception that applies to you or something maybe that we didn't cover today. Do be sure to reach out so that you can get the legal advice that you need. But thank you so much for joining me today for our Family Law Hour. Do be sure to subscribe so that you get alerts for our next live event and you can hop on and ask any questions that you may have in the chat, and we'll be able to provide some information to you directly should you need that. So thank you so much. Enjoy the rest of your day, and I will see you soon.